What's up, everybody? We're going to be talking all about trademarks and the cannabis industry today on a webinar that we have called Cannabis Trademarks 101. Joining us will be Sahil from Juristy Law. Let's get into it, and you're going to learn a lot. So stick around, thumbs up, like, subscribe, share this. Hey, Sahil, thank you for joining us. A lot of people that signed up, they went over to cannabisindustrylawyer.com and they filled out a form that they can find there. But why don't you introduce yourself and tell people about it?
Hey everyone, my name is Sahil Malhotra and I'm an intellectual property attorney at Juristy Law.
Let's do a deep discussion into office actions. What does an office action mean for your trademark application, and what are the next steps? Because like some of our clients, they may apply and then wait that 9 months. They might have picked numerous various classes, and so they've paid more than one filing fee, and they're really trying to put a brand out there. Bang, they get an office action. What do we do?
Let's say you filled out a perfect application. Let's say the product that you are applying for is a hemp product, and use the legal definition for the hemp product, and your hemp product contains CBD. As long as that, and if let's say that hemp product is also meant to be consumed as food or beverage, more than likely you're going to get an office action. An office action basically is just an examining attorney looking at your application. They're going to run your name, logo, slogan, whatever you're trying to apply to protect through their database and through an outside database, where they'll compare any other mark that exists that might conflict with this mark. Not only conflict in name, sound, connotation, appearance, but also maybe is in the same industry, same goods, same products, same services maybe they're providing. That's a big no-no. More often now, that's called a 2D refusal, likelihood of confusion. And to overcome that, you have to argue against how your mark is not similar or how your mark is dissimilar from the conflicting mark.
So that is a 2D confusion. And so like now you're starting to sound almost like litigation. Is an office action litigation where you have like a plaintiff and a defendant, but then it'd be like an applicant and then the government?
So no, you're just, at this point, you're just back and forth with the examining attorney. There's gonna be multiple opportunities for you to resolve this office action. But more often than not, you're required to address the specific issues in each office action. It's still not in litigation process yet because you still have an opportunity to overcome that refusal. So let's say we have a hemp-based product with the proper CBD definition. We're gonna get the initial refusal, but more than likely, the examining attorney is just gonna ask us for additional information where we clarify that we're not stating any medicinal therapeutic products, and we just overcome that refusal.
I would like to see that on this one, because I have never ever seen a dog walker that wasn't sold in a dispensary. I've never seen the hemp version of dog walkers.
Yeah.
I have seen a lot of hemp when it comes to cookies, like Berners Company cookies, and it makes me think that sure, Berners probably is taking all the cookie stuff that he can and trademarking it all into the hemp, but fascinating stuff.
I would also imagine dog walkers is probably placing their CBD or CBD only pre-rolls in probably CBD only stores, because it kind of, for them, maybe on a supply chain basis, doesn't make sense to put it in their dispensary. Maybe there's already other CBD products at the dispensary that do pretty well, or like the type of CBD products that people are looking for at a dispensary. I don't know how many people are going to dispensary to look for CBD products unless they're edibles or even tinctures. And since dog walkers exclusively deals in pre-rolls, I imagine they probably place their products in the CBD only store or more CBD heavy kind of like spaces. Yeah.
Interesting. Okay. And so this office action, now you've gotten that, and it said maybe it's just confused, and you follow up with them and they let you go. What else can let's walk through the lifespan of an office action.
Let's say you overcome that office action. You get to the point of where everything is clear. The USPTO says you're good to go. We're going to publish you in the official Trademark Gazette. Now, what that means is you're going to be published for opposition. Anybody who wants to oppose against your mark's final registration has 30 days from the day of your mark being registered in the official Gazette to oppose your registration. Now that's usually just called an opposition proceeding, and they can put up many claims. So this is where they can also claim there's a likelihood of confusion. Maybe they claim you were trying to get this mark through fraud. Maybe they're saying that your mark is too descriptive. It is generic. And those are two standards where you're not afforded trademark protection. So that's kind of a scenario you're probably looking at. And in that scenario, let's say you get an opposition proceedings, that's where we get into litigation. That's where we go to the TAB, which is the Trademark Trial and Appeals Board, where you kind of, do the similar process of what would be federal litigation, just cheaper and a little more fast paced. You're working with admin courts in that scenario.
So you have an office action that doesn't go your way. And then what did you call that? The next one? The
office action goes my way. We're good. We're getting published in the official Gazette, and there's an opposition period for 30 days. Okay. That's where if somebody opposes us, then we start opposition proceedings at the Trademark Trial and Appeal Board.
Opposition proceedings, can they be brought by the USPTO, or does it have to be somebody else?
Not by the USPTO. It's usually it's a third party. That is probably, so more often than not, when I have clients and they have like registered marks, they want to do monitoring or watch services as well, which kind of means that I on top of Google alerts, I use certain other third-party vendors which allow me to monitor people's brands and see if there's anything out there that might be conflicting or possibly infringing on my client's brand. This is the same thing anybody else would do. Somebody else, maybe you're someone out there, maybe Sunnyside is out there. They probably have a monitoring and a watch service employed by a trademark law firm where they're looking for anybody who is trying to apply for marks that might be similar to theirs. And as soon as they see something like that, they will be filing for an opposition proceeding to try to oppose this mark from being registered. That's kind of.
It really is like litigation. It's two parties. It's not the government saying that you've done something wrong. So it's not like a prosecution.
Yeah, it's the third party at that point. And when you get to the TTAB, when you get into opposition proceedings, you're definitely in that point in litigation. It's cheaper than going to federal court for a trademark infringement, but still, it's litigation. It's just a little bit faster, and the courts usually use a standard which is a little bit narrower than the federal circuit.
Okay, and so that's an office action that may be turning into an opposition. What do they call the opposition terminology again?
Opposition proceeding. Yeah.
That's a fancy way, a very government way of saying, kind of like litigation. Opposition.
Absolutely. As soon as we're done with opposition, let's say you get registered, and maybe somebody didn't catch that opposition. For a certain period of time, someone is still allowed to bring a cancellation proceeding against your mark. It's similar to the opposition proceeding, but there are different standards that are applied in the cancellation proceeding versus the opposition proceeding. It's the same thing. It goes through the TTAB. Again, the standards are a little bit narrower, the process is a little bit faster, and it's comparatively cheaper than to go into federal court. Same thing, a third party maybe missed the opposition period and now wants to come for cancellation. It's a little harder standard to get through, but it's still another opportunity for a third party to bring that case.
Okay. Awesome. Well, hey, man, I really do appreciate you coming by and discussing not just trademarks in cannabis, but then also we discussed in depth office actions, and we also discussed in depth the different categories of the trademarks and how they apply and various things. And so hopefully you guys enjoyed this month's webinar. Next month, we'll be back with another one. Again, thank you so much for joining us, everybody. Consider becoming a member of the channel, and then, of course, tune in to more episodes of Cannabis Legalization News. And if you have any questions about what next month's webinar should be, leave it in the comments, because we're always looking to do one webinar a month. that's relevant to entrepreneurs in the cannabis industry. So we'll see you next time.
Bye.
All right.
Brown chicken brown cow.